When I made that screencast, I didn't know the difference between the OC Weekly and the OC Register. OC Register would be a much better example, a classic daily paper. Anyway, here's some of the dimensions that you might have found to make an argument for why to apply Barber v. Time or distinguish it in the Erickson versus OC Weekly. So I'm going to give you just a few of those, not a ton, but I'll give you some of the ones that students tend to come up with, then kind of tell you what to do with all this. Because if you feel like your head's swimming, don't worry, it's not quite as bad as it feels right now. So one dimension would be the nature of the news story. And I see this articulated in a whole bunch of different ways. The focus of the story, the nature of the article, whatever. In Barber v. Time, Time is claiming that this is newsworthy. But the reality is that it's actually kind of a tabloidy, gossipy kind of thing. It's mostly interested in treating Dorothy Barber like a pretty little freak. I mean, starving glutton, come on. This is not exactly a neutral public interest story. Whereas Erickson v. OC Register, that actually is a legitimate, bona fide local story about a new neonatal program in the area that would actually be relevant to maybe a lot of readers. So you could argue that the fact that the article is in the public interest much more than this mysterious illness, which, by the way, you don't learn anything about the illness. The OC Register story, you could argue, warrants a lot more protection. So you could distinguish Barber v. Time from Erickson v. OC Register based on, the idea of the nature of the news story being in more of the public interest. Another dimension you could look at would be consent. This is one I see a lot, so I really want to address it because I think it's interesting. A lot of students will come up with it, and it's funny because they wrestle with it because they know that there's something not quite right here. Some students will argue that in Barber v. Time, Barber, of course, actually had the chance to say no. She actually said, leave my room, don't take my picture. Whereas Erickson, being completely clueless about what was going on, never actually said no, because she didn't know the picture was being taken. So I'll have students who will put those two out there, and then they're like, this feels wrong, but I guess I could argue to distinguish, because Erickson didn't say no. And no means no, but I guess no means I don't know. So Erickson didn't say no, therefore the consent is murkier. But, of course, you guys know. There are lots of different ways to say no, and one of them is to not even have a chance to say no, as witnessed by the case that happened earlier this summer with a Stanford student who raped an unconscious girl. And she didn't necessarily say no, we'll never know for sure, but that didn't mean that it was okay for him to have sex with her unconscious body. So even if you put these two things, your common sense obviously should tell you that you may be trying to create a reason to distinguish, but the reality is that you should still apply. Neither woman gave consent to have her picture taken or to have her medical condition publicized. And again, for this exercise, I tell you to wing it and go crazy. But at the end of the day, I want you to trust your gut when you're trying to decide whether to apply or distinguish. Okay, another dimension would be damages, the harm that was done. Now, in Barber v. Time, I gave you some context to suggest that there definitely was harm, that she was presented to the whole country as kind of a freak. And so her humiliation, which of course is general damages, is solid. So national embarrassment definitely constitutes damages. And some students will argue that unwed pregnancy isn't that big a deal, which is true. I mean, we have entire reality shows based on it. And it's a nice pick. It actually is a very flattering pick of me from 4 years ago, 5 years ago. Yeah, I'm ancient now. So the harm isn't that bad. Of course, I give you additional information, the fact that her family may disown her and now her pothead ex knows about her. So you could basically make either argument here too, depending on how you set it up. And that's kind of what I want to get to, that in law, this is why they're lawyers. You will have one side who will make one argument because that's the conclusion they want to reach, and another side make another argument. So even though I know that doesn't make a lot of you very comfortable because you want to know that there is a right answer, the reality is I want to, from the start of this class, give you permission to have subjective opinions and show you, especially in this first section of the course, that that is actually a part of the fiber of law. That what I will be grading you on in this course is that you are using the tools that I'm giving you and showing that you know how to use them. But there's going to be a lot of room for you to be making subjective rulings, essentially, as judges. Another one that's kind of interesting that students will bring up a lot is location. Now, obviously, both of them were in hospitals, and right there, hospital suggests some level of privacy, right? But if you wanted to be a little picky, you could argue that Barbara was in bed in her hospital room when the photo was taken. And that really suggests about the highest level of privacy you can imagine, that her privacy was truly egregiously invaded in bed. I mean, you can't picture a more vulnerable state for someone to be in. Whereas Erickson was actually in something of a public hallway where anyone in the hospital could see that she was pregnant. So it would totally make sense if you distinguished and argued that Erickson's expectation of privacy, and that's actually going to be a term that you'll learn in the privacy section, her expectation of privacy was far less than Barbara's because she was in a relatively public space. The reality, though, is that if you're in a hospital, we consider your level of privacy or your expectation of privacy to be pretty high, whether you're in a public hallway or in a hospital room. The reality is this scenario would never happen, or if it did, the reporter would be fired. Or maybe the editor would be fired because it's just common sense that when it comes to medical information, it's one of the last few sacred cows. We have no respect for privacy in almost any other dimension, but that's the one area where we feel like people should be protected. But that one's another one that students will come up with. But let's go back to looking at the precedent. Publishing someone's name and picture along with their medical information without their consent constitutes an invasion of privacy. So if we look at those ingredients for what constitutes an invasion of privacy under this precedent, Barbara v. Time, we've got publication, identification. In Barbara's case, that was both by name and picture, the publication of medical information specifically, and the absence of consent. So what the Barbara precedent, i.e. the rule, sets up is that when you have these, when you have the publication of medical information and you identify the person and that person is not given consent, under Barbara, which granted is only a Missouri case, but today pretty much all states have something similar to this, you have invasion of privacy. Actually, what you're going to find out later in the class is you have publication of private facts. So what it really comes down to, and what you're really going to be doing in this class, is when you get a scenario and you have a precedent like Barbara v. Time, you're just going to do a common sense reading and be like, well, that's what that says is an invasion of privacy, so let's see if we've got it. Like, Barbara, you had publication, same with Erickson v. OC Register. Barbara, she was identified by both name and picture, so was Erickson. Medical information was released in Barbara v. Time concerning her weird, starving glutton mystery illness. Erickson's medical condition of pregnancy was also publicized. And then finally, neither woman gave consent. So at the end of the day, what you're really going to be doing in this class is something that is just much more common sense, which is, here's the precedent, does it fit this scenario, in which case you will generally apply it. So here you apply it. Erickson's case had all the same elements included in the Barbara rule/precedent, so you should obviously apply and find that the OC Register is guilty of publication of private facts. What it's going to come down to in this class is not as nuanced as this assignment makes it seem like it's going to be. So for example, if you tried to apply a precedent that was about someone going to jail for criticizing the government to Erickson v. OC Register, you would get that wrong. Really, it's going to come down to just finding the precedents that clearly fit the scenario that you're given and not something that is completely different. So it's not going to be as nuanced or as difficult as this assignment may make it seem. It's actually going to be pretty straightforward. Again, one of the reasons I want you to do this assignment is to show you how lawyers and judges can decide to apply or distinguish based on nuanced things. In other words, it's to show you how there's room in the law for subjectivity. And that's going to be important because as we go through the semester, I'm going to teach you the rules, teach you the tools, etc. And I'm also going to teach you about cases starting very, very soon where you should question the ruling. And not only that, but you'll see that there will sometimes be, 5 justices on the Supreme Court who take completely different paths. And so I want you to be comfortable with that and know that I've got you, that all I'm going to be testing you on and all I'm going to be training you to do is to use the correct tools at the right times. And if you're doing that, even if I completely disagree with how you applied it, as long as it fits the rules of the frameworks, you're going to get the question correct. So that's kind of the point of this assignment. And all of this will make more sense as we go on over the next couple of sections. One final note. This course is what I call front-loaded. In other words, your learning curve in the first 4 sections of this class is going to be incredibly steep. And I'm sorry, there's no way around it. It's, we've got to do legal system. You have to learn what precedents are. You have to learn structures. But if you will just hang tight and know that it's going to be really steep in the front end, it's going to feel better and better as the class moves on. The class is designed so that the end gives you kind of breathing room to feel like you really understand everything. So it's going to feel brutal in the front end. And obviously it's going to be tough all the way through. But if you can just hold on for the front end, you'll be just fine. All right, good luck, guys.